have everybody, huh? Okay, we'll go ahead and get started. Welcome, everyone. I now call to order this special meeting of the Anchorage Assembly. It is Tuesday, April 19, 2022. Madam Clerk, would you call the roll, please?
Yes, Madam Chair. Mr. Weddleton. Ms. Allard.
Here.
Mr. Peterson.
Present.
Mr. Rivera.
Present.
Ms. Kennedy.
Here.
Ms. LaFrance.
Here.
I understand Mr. Constant is excused.
That is correct.
Thank you. Ms. Zolotel.
Here.
Mr. Dunbar.
Here.
Mr. Perez-Verdia.
Here.
I understand Ms. Quinn Davidson is also excused.
Yes, that is correct.
Madam Chair, you have a quorum.
Thank you, Madam Clerk. Mr. Hess, would you lead us in the Pledge of Allegiance? Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Peterson, would you read the land acknowledgement, please?
Thank you, Madam Chair. A land acknowledgement is a formal statement recognizing the indigenous people of a place. It is a public gesture of appreciation for the past and present indigenous stewardship of the lands that we now occupy. It is an actionable statement that marks our collective movement towards decolonization and equity. The Anchorage Assembly would like to acknowledge that we gather today on the traditional lands of the Dena'ina Athabascans. For thousands of years, the Dena'ina have been and continue to be the stewards of this land. It is with gratefulness and respect that we recognize the contributions, innovations, and contemporary perspectives of the Upper Cook Inlet Dena'ina.
Thank you. And I want to note for the record that we have been joined by Mr. Weddleton. We have one laid on the table item, which is supplemental but will need to be incorporated into the agenda. So I will read this item into the record and then I will ask for a motion to incorporate it into the agenda. Unnumbered AIM-2022, meeting date April 19, 2022, from Assembly Chair LaFrance, subject, appeal of the denial, redaction of information in Public Records Request Response, March 28, 2022, request for OM 2021-1426 documents. Could I get a motion?
Move to lay this item on the table.
Second.
Actually,
Move to incorporate.
thank you. So a motion
Second.
to incorporate has been made by Mr. Dunbar and seconded by Ms. Zolotel. Since this item is supplemental, we don't need to vote on the to lay it on the table. Is there any opposition to incorporating this item into the agenda? Seeing and hearing none, this laid on the table, unnumbered AIM-2022 has been incorporated into the agenda. The two items on the agenda tonight involve appeals of the denial of public records in custody of the Assembly branch of our municipal government. The process to review these items is different than the Assembly's legislative role because these are administrative or quasi-judicial proceedings and require the Assembly to be impartial, refrain from ex parte communications, and make a decision based only on the record before us. Anchorage Municipal Code Section 3.90.060 outlines the process for records requests. Per code, quote, information pursuant to this chapter shall be furnished promptly to the requesting party unless the information requested is declared privileged or confidential pursuant to applicable federal, state, or municipal law, end quote. AMC 3.90.060 also provides that a requester may challenge the decision to withhold records by filing an appeal. An appeal of the denial of Assembly branch records or utility records goes to the Assembly. We are here today to take up two appeals concerning the denial of records. The question before us for both item 4A and item 4B is whether the denial of records of information was appropriate under the rules for exceptions to public records access. Based on AMC 3.90.060, the Assembly established a process for addressing such appeals. If a requester appeals, a packet is put together that includes the original records request, the denial, and the appeal. The requester and the public official that denied the information are invited to make a written statement in support or in opposition to the appeal. The Assembly can make its decision based on the packet and these written statements. The Assembly's decision can be appealed to the Superior Court. And I just want to note that the documents that we have include a resolution for each item, an AIM, and then attachments pertaining to the request and appeal, and those are available online as well. We now have before us item 4A, resolution number AR 2022-124, a resolution of the Anchorage Assembly regarding the appeal of denial of information in public records requests for Ombudsman's records in case number OM 2021-1426. And I do want to note that, as I mentioned, this is a quasi-judicial proceeding, and members are to refrain from ex parte communication. So I do want to disclose that earlier today I did receive a phone call from Mr. Grober expressing initial disapproval of the memorandum that was part of the AIM that was laid on the table, and specifically that the timing of the memorandum was released so close to this meeting. I informed Mr. Grober that I could not have a conversation with him because of the ex parte nature of the proceedings, so I wanted to disclose that. At this point, I will go to Ms. Zelatel for a motion.
Move to approve.
Second.
Moved by Ms. Zelatel, seconded by Mr. Rivera. Ms. Zelatel?
Thank you, Madam Chair. At this point, I'd like to ask Council to summarize the request before us, the reason for denial, and the requester's statement for appeal. And then after we've heard from Council, any statement from Mr. Hess, the Ombudsman, as to why the information was denied. Thank you.
Yes, thank you. So the ask is to summarize the information. I provided the appeal packet, so you would have all of that information before you. The first page, the top right corner of each page of the attachments to the first AIM 62-2022, the top right corner has Bates numbering, so the first page 1 in the middle request is for a draft report on complaint by Grober, RE, ADA investigation in action by MOA to be circulated to agencies as requested via email of even date. That's basically the request, the draft reports. And then the response from the Ombudsman, I think this is like 2 days later. It's Bates number 3 in that packet. And the rest of it is, I think you can find in the second paragraph, the Ombudsman's preliminary investigative reports or pre-decisional documents was his response that are part of the deliberative give and take decision-making process. And then he cites 2 code sections, and at the bottom, those are the reasons outlined above for his denial. The request for appeals on page 4, down towards the middle of the page, the email from Mr. Grober starts, I would like to appeal the Ombudsman's decision to refuse production of the penultimate decisional document to the complainant. His words, quote, so he offers some argument in that communication as well that's was provided for review. And then the page 8, I had a letter from me that I'm trying to make this a standard procedural correspondence for appeals of public records. So I have the same letter for the next case as well, just outlining it and in bold informing them of when the appeal date is set before the Assembly, before this body. And then today's AIM, I think I should mention, that was generally because the deliberative process privilege that's referred to in the Ombudsman's letter as the basis for denial, that's not described in code or in statute that you could simply quote and send out. It's described in Alaska case law. So I basically thought that this body, if you're trying to decide if the deliberative process privilege is appropriate or not, well, you need to understand what it is. And so this only tried to say this is what the Alaska Supreme Court has said the deliberative process is. You know, there's 3 elements to it. It's got to be pre-decisional, it's got to be a deliberative process, and it's if those 2 factors are met, then there's a presumption that the information is non-disclosable. And there's a balancing test then where the proponent asking for disclosure can say, well, the public's interest in having the documents outweigh the government's interest in not disclosing these types of things. So I just wanted to lay out the law there for you and not speak to the merits of the appeal and Mr. Grober's arguments in his email and so forth, but just say what the deliberative process privilege is, so as you consider it, you can apply it or see how it was applied. And then I think I should mention here that my role can be somewhat mixed at times, and I do have a duty and obligation to function in the different roles that I have. Earlier in this process, I did advise Mr. Hess, the Ombudsman, about what that deliberative process privilege is. Basically the same thing in the AIM. And just to ensure that you have an impartial legal advisor, I've asked Ms. Politroni to be here as well. But I'm happy to advise or for you to ask Ms. Politroni questions if possible. So with that disclosure, I think that answered the request.
Thank you, Mr. Gates. Ms. Zalatel?
Thank you, Madam Chair. I just wanted to check with the official who denied the information, which would be Mr. Hess, if he had anything he'd like to add.
If you could press the button there.
Oh, sorry. So our preliminary reports are pre-decisional deliberative documents. It's a consultation process with the department that the complaint involves. And having that confidentiality is important because it's not unusual for me to change my determination or my opinion regarding what the department did or failed to do, and the investigation is not completed and closed until after the preliminary report is provided to the department, they're consulted, and then I review their comments, and then the case is closed. So it is still an open investigation. It's part of a consultation process. There have been times when I did not even issue a final report after the response from the department. I changed my determination entirely, and I did not issue the final report. And it's important, you know, this is recognized in state statute, says that the state ombudsman's reports that are sent to the departments are not public documents until they're issued. And it's important that we have that confidentiality because we rely on the departments being willing to work with us. And in this social media age, somebody could post a preliminary report that is part of an incomplete investigation and publicly post a comment by the ombudsman that is incorrect, that would be changed in the final report. So I think we meet the criteria for a pre-decisional deliberative process with our preliminary reports.
Any follow-up, Ms. Zalatel? And I've got a couple more members in the queue, Mr. Hess. First is Mr. Perez-Verdia.
Thank you, Madam Chair. Actually, my question isn't for Mr. Hess, it's for Mr. Gates. Well, you may weigh in, but you set a standard for the criteria that it must meet, and part of our decision should be based on that criteria, whether it meets that or not. How are we to determine whether it meets the criteria if we have not seen the contents of it? So I guess that's my question is, how are we as a body able to determine whether it meets the criteria if we haven't seen the contents?
That's a very good question, Mr. Perez-Verdia. Part of it is, of course, wanting to decide on the content of this specific matter. I think another part of these issues are, well, is there a more blanket protection for this type of work? And often that's codified or in statute and so forth. So, for example, redact social security numbers because that's personal information, but do we need to show you social security numbers, or is that a blanket protection from disclosing them? And I don't know if that's the best analogy, but it is an easy one to understand. So I think that here we have the code provisions cited by the Ombudsman and his reasons, and those code provisions say preliminary reports aren't public and the final report is public. And I think that that's because of the nature of his work. It's investigative work, and even though you haven't seen the content, that work is protected. So I hope that might answer to your satisfaction, to answer your question.
One follow-up. So maybe a better way for me to ask it is who has made the determination that it meets the criteria? Is that solely Mr. Hess, or has someone else been involved in that consultation to determine whether it meets the criteria or not?
Well, in this specific case, I think you would have to ask Mr. Hess who was involved, because I didn't see the content myself either.
Yeah. Mr. Hess, were you the sole person who made the determination that it met the criteria?
Yes, on legal advice provided by the Assembly Council.
Thank you. Thank you, Madam Chair.
Thank you, Mr. Perez-Verdia. Mr. Weddleton?
Thanks. So, Mr. Hess, so is this, would you deny giving anyone the preliminary work in all cases, or is there something specific to are there certain ones that have something in them that would make it something you deny, or is it just always that's your policy or habit?
It's been the policy of the Ombudsman's office for the last 45 years. Actually, today is the 45th anniversary of the office, but it's because we don't know what the result is going to be, because we have not received the response from the department to the recommendations in the report. So the investigation isn't concluded. So providing that, the code actually states that the Ombudsman may provide, it's not clear, and the code probably needs some revisions, but if you take into account the different court opinions and how the state ombudsman's office operates, if you look at my code, the Ombudsman's code, it says that I may provide a preliminary report to the department to consult with them. And it says that the final report is a public document, and I have to provide a copy to the department and to the complainant. So while it may not spell it out clearly, I think it definitely implies that the preliminary report is not a public document, because it gives me specific permission to share it with the department that I'm consulting with, and it says that the final report is a public document.
So to follow up then, so is the preliminary report, is it, so when you have an issue, you will talk to someone, you just kind of gather quickly available information and your long knowledge, and you kind of write up, I think this is where what should be done, and then you send that to the departments, you get their feedback. So is that preliminary document just your first draft, or does it include comments from
It's my preliminary take. The case is not closed. The investigation is still open. But I've reached a point where I feel I'm ready to make a determination and recommendations to the department. And then I send the preliminary report to the department or departments. They review it, and they may come back, frequently they'll come back with request factual changes, that your assumption here is incorrect. Here's a document that shows this is incorrect. We accept that recommendation, or we agree with one of the recommendations but not the other recommendations, so it's a give and take, and then I will finalize the report and issue it.
Okay, can I just, so is Mr. Grober looking for your report and also the department response, or just your initial report?
So 7 days after his request for the preliminary report, I issued the final report and provided him a copy, and the final report always includes the department's response to the recommendations. So 7 days after his request for the preliminary report, he received the final report, and the department concurred with my recommendations.
Okay. Thanks.
Thank you, Mr. Weddleton. Ms. Kennedy?
Thank you, Madam Chair. My question's in regard to confidentiality, and I certainly understand that there's information, documentation, content, that could apply to this confidentiality rule, but I was just wondering if there's any degree of confidentiality that's afforded an ombudsman just by relationship, something that's similar to a client-attorney privilege, that kind of confidentiality. Does anything like that weigh in on this particular situation, or do you even have that kind of coverage? Thank you.
So the code says that any documents or testimony provided to me with the understanding it would be confidential, I have to maintain that confidentiality. Now, the state ombudsman and most ombudsman's offices actually has in their code or statutes broader protections regarding confidentiality of files and documents than our code has. I've always felt it's a little bit of an oversight in our code if you compare it to the state ombudsman's statute.
Okay, thank you. Well, in other words, that does exist to some degree, but that's not really playing into this particular situation right now, or could it, or should it?
I believe that a preliminary report is a different situation than the work product from a file. It's two different issues. I think the preliminary report, based on the code that is written and different court decisions in Alaska and looking at the state ombudsman's code, I believe the preliminary report is not a public document.
Thank you. Thank you, Madam Chair.
Thank you, Ms. Kennedy. Mr. Rivera?
Yeah, thank you, Madam Chair. So based on everything that I have heard so far, I am ready to move forward with checking one of these boxes or making such a motion. Are we in a place where we can do that? Does that need to be done in executive, or are we good to go?
We are good to go. You may move an amendment.
Great. Yeah, so then I'm going to go ahead and move to check the box denies the appeal and the decision of the public official is affirmed.
Second. So a motion to amend to check the denies the appeal box has been made by Mr. Rivera and seconded by Ms. Zelatel. Mr. Rivera?
Yeah, thank you, Madam Chair. As much as I appreciate Mr. Grober bringing this appeal to the Assembly, I think just based off of both the AIM that was submitted by Assembly Counsel as well as the testimony that we have heard, or rather the words that we have heard today from Mr. Hess, that I think it makes sense for us to deny this appeal. I think, in my opinion, Mr. Grober got what he wanted with the final determination, which Mr. Hess told me that he received. Thanks.
Thank you, Mr. Rivera. Ms. Zelatel?
Thank you, Madam Chair. I agree with what Mr. Rivera said, and this seems to be within the typical work pattern of the Ombudsman's office. Nothing seems to have gone outside of the normal policies and procedures that the Ombudsman uses to process these complaints. And I do want to value that cooperative relationship that the Ombudsman needs to do the job and to really investigate the complaints that come forward. Thank you.
Thank you, Ms. Zalatel. Mr. Perez-Verdia?
Thank you. Just seconding my colleague's comments. Thank you, Mr. Hess, for your work. I would agree that we need to move forward and deny this request. 45 years of practice should not be changed in this particular case. The code is clear, to me at least, and the final report includes not only the final information but also the response from the department, which should have given this requester all of the information he was looking for. Thank you, Madam Chair.
Thank you, Mr. Perez-Verdia. Seeing no other members in the queue, members may proceed to vote on the motion to amend AR 2022-124 to check the box denies the appeal and the decision of the public official is affirmed. The amendment passes 9-0. We are now back on the main motion to approve AR number 2022-124 as amended. Seeing no other members in the queue, members may proceed to vote on the motion to approve AR 2022-124 as amended. The motion passes 9-0. We now have before us item 4B, resolution number AR 2022-125, a resolution of the Anchorage Assembly regarding the appeal of denial of information in public records request number 2022-13. Ms. Zalatel?
Thank you, Madam Chair. I move to approve.
Second.
A motion to approve has been made by Ms. Zalatel and seconded by Mr. Rivera. Ms. Zalatel?
Thank you, Madam Chair. Just like with the prior item, I'd ask Assembly Council to summarize the request, the denial, the requester's statement for appeal, and any statement denying the information after appeal.
All right, thank you. So this appeal is from Mr. Russell Biggs, who's represented by counsel, Mr. Samuel Severin. This request came in following a previous records request. And this is on 4B, the AIM 63-2022 and the attachments. The records request is on page 1 in the public records request form, down in the middle, and I'm going to paraphrase, if I may, because you can read it for yourselves, of course, but this is a request for recordings and transcript of all direction given to the attorney, me, during an executive session held, I think it was February 1st, regarding what's to be released. And so it's a portion of an executive session recording or transcripts. And then the denial message is my letter that was in response. And as I mentioned, we were also considering at that time a previous request from Mr. Biggs that Mr. Severin was also representing him. And I got this request while responding to the previous one. And so my letter that's on page 3, oh, excuse me, that's Mr. Severin's memo. A letter on page 5, dated March 3rd. The first paragraph was in response to the outcome of that executive session in his previous request, 2021-11, and the re-release of the records that were requested. The next paragraph in the middle is regarding this new records request for the transcript of the executive session recording. And it's basically saying, well, there are no transcripts, so there's nothing to produce there. And as for the recording, we do record our executive sessions, and the Assembly at its meeting, in open session, voted to not disclose. And so I don't have any authority to override that, and that was basically the gist of the response there. So I could not produce that. And I think that, let's see. Excuse me. The next page, I do have a little follow-up to Mr. Severin, who was asking what was the records request number for this new one, 2022-13, which I hadn't assigned at the time, or I didn't have the number at the time of my March 3rd letter. However, I responded and I followed up with the motions that were here in open session so that it was clear what the motions were and what occurred as obtained from listening to the recording of our open session at that meeting, February 1. And then, excuse me, we have a March 23rd memo from the attorney for Russell Biggs. And, well, it's a little lengthy, but the basic thrust of this and also a, excuse me, memorandum dated I'm sorry, I'm going to address them together. On page 15, the first one on page 8, March 23rd memorandum, another one, page 15 and April 13th memorandum. The basic thrust is that not everything that's in executive session is protected or privileged, and that he didn't leave that direction to council as to what to do after that executive session would be protected and should be disclosed as a and Mr. Severin has a number of arguments at length here. Now, both memorandums attach the previous request and the letter of denial, and so you see some duplicates here in the attachments. And I believe that brings us to today, and my letter that is on page 22 from April 14th, just describing that the Assembly would hear this appeal this evening. And then I guess for a disclosure here, this case is a little bit different than the previous one, because as counsel and I was the final decision maker not to disclose the records based on basically, as I described, that it was an executive session, there was no transcript to release, and the Assembly as a body voted to keep the, never release the executive session recordings, so I had no authority to release it. That was my decision, and because of that, I advised the body and made the decision here that's now on appeal, and I had the municipal attorney come to tonight's meeting so he could advise you independently of me if that is necessary.
Thank you, Mr. Gates. Ms. Zalatel?
Thank you, Madam Chair. I move to amend and check the denies the appeal and decision of the public official is affirmed box.
Second.
So an amendment has been moved by Ms. Zalatel to check the denies the appeal box, and it has been seconded by Mr. Rivera. Ms. Zalatel?
Thank you, Madam Chair. The Assembly has already weighed in on whether or not to release this particular recording when it came before it after the executive session. Thus far, in reading the packet, no particular compelling information has been provided that has changed my mind for that vote. And so I think we should deny the records request. Also, there's nothing to suggest that in the documents that Mr. Gates didn't follow the direction provided by the Assembly. Thanks.
Thank you, Ms. Zalatel. Mr. Weddleton?
You know, it just seems really odd to not tell the person who appeals what instructions we gave to the attorney. I mean, how, I don't even remember what I'm allowed to say because it was an executive session, but it just seems odd. I think we all know we didn't completely deny his appeal. But we denied telling him what we didn't deny. It just doesn't, it puzzles me, and it did, as you know, before, and it still does now too. It just seems unfair to not let him know what we did. Somehow, I mean, whether by opening the audio or allowing a transcript of just that part that said, here's what the instructions were. So anyway, I think I'll vote against this just based on that, but it just, is there some way we can do that? Tell him at least what we decided? It just seemed very odd, this whole process. Thanks.
Thank you, Mr. Weddleton. Was that a question to Mr. Gates?
It was a question to Mr. Gates, but I guess there's no appropriate answer because I didn't get it last time either, so no, I guess no need to dwell on it.
Thank you, Mr. Weddleton. Mr. Perez-Verdia?
Thank you, Madam Chair. I guess I'm trying to make a distinction between the reasons that the recording was not allowed to be released, which I think there were valid reasons for that, and the specific advice that was given. And so I guess I'm curious about the distinction between those two things. So I guess I do want Mr. Weddleton's question to be answered, is that there were legal reasons that the recording was not allowed to be released, which was the basis for the Assembly's decision. However, the question is that is the advice that was given to you, does that fall under the same legal reasons that the recording as a whole were not released?
Thank you. I hope I answered your question. It was a little.
Well, let me try to rephrase.
However, I think. Oh. Well, if I may.
Go ahead.
The vote to not release executive session recordings, or the vote on executive session recordings in the release date, it's about the whole recording. It's a one thing, and it's the whole time period of the executive session. And here the request is for a portion of it, but we didn't make any vote on a portion here and there. Now, I am aware, and I don't know, I could name a case off the top of my head, but there's case law that says just because you have a document, for example, that's public record, but you bring it into executive session and discuss it, doesn't make that public document suddenly confidential and privileged. But the content of executive session, there's a whole bunch of things we talk about. Some things we talked about in this one, I believe, are privileged, confidential, and part of the reason we went to executive session, but not everything that was said and not every document we looked at there was necessarily privileged and confidential. So this request is to parse out a piece, and the piece was the direction given to the council. Our municipal code on executive sessions and state statute on open meetings allows direction given from the body to legal counsel in the executive session, and that's just what we did. So the specific direction that we're looking at here and the words of it, perhaps not, I mean, would be something that doesn't need to be per se on its own in a vacuum confidential or privileged. So that's for, I think, the body to decide. And I would also, before you asked your question, I asked to speak to make one clarifying point about the record here before us, if I may, but I wanted to make sure I answered the question. Mr. Perez-Verdia.
Thank you. Yes, you did, and I just have one other comment to make before I give up the mic. Yes, I will be voting to approve the denial. I will also just say that I believe that there was substantial reasons to not release this information, and there's nothing here really, and so it's more about protecting the privacy of those things that need to be protected, and then the risk of not doing that. So I will be voting to approve the denial. Thank you.
Thank you, Mr. Perez-Verdia. Mr. Gates.
Thank you. And listening to Mr. Waddleton's comment earlier, I was reminded I wanted to point this out here on page 5, my letter to Mr. Severin that denied this request, the March 3rd letter. I pointed to the second paragraph, but the first paragraph describes a re-release of the records from his earlier request, and in it I tried to divine that if you read this, the revisions for the re-released records were part 1, pursuant to number 1, the Assembly's directions, and I didn't say what the directions were. But then in number 2, I continued to say subsequent discussions with my clients who, the communications with the subject of that request, and then holding the privilege for the email question, and their consent to further on redactions in addition to those per the remand directions from the Assembly. And I wanted to make sure that it was clear here what I'm stating is I got direction from the Assembly and then talked to those clients, and the re-release was more than the direction from the Assembly. So I'm not sure if that was really clear, but I thought that's an important thing to understand.
Thank you, Mr. Gates. Mr. Rivera?
Thank you, Madam Chair. Yeah, Mr. Gates beat me to the punch a little bit. So I agree with the rationale made by Ms. Zalatel. We had a reason for making sure that the recording will never be released. We voted on it by a majority vote, and I see no reason to change that decision. So I will be supporting this motion to deny the appeal. I guess I'll go ahead and just, for folks who are looking at it, page 22 of the packet, the change, I'll just read one of the sentences there. The changes from the December 17th redactions should be obvious. They are responsive to bases number 1, 3, and 6 in your February 1, 2022 correspondence. So I think Mr. Gates does a pretty artful job of trying to be as responsive as possible to the appellant. Thank you.
Thank you, Mr. Rivera. Ms. Allard?
Thank you, Madam Chair. And is Mr. Severin here? Is that you, Sam? Okay. Madam Chair, first I just wanted to say that I was one of the members who voted no. I find in an executive session there are some things that for the time being may be sealed for a certain amount of time, duration, but the majority of the body voted for indefinitely, and I take issue with that. But I wanted to ask Sam, can I call you Sam? Yeah, that's okay. You call me Jamie.
And Ms. Allard, continue. I just want to remind members too that per the letter of April 14 on page 39 from Mr. Gates, that the Assembly may ask limited questions relevant to the appeal to the parties. Questions should be clarifying and not used for oral or legal argument.
Thank you.
If you want to go ahead.
Thank you, Madam Chair. Sam, so can you clarify a little bit when you say remand on the legal side of things, the definition, and maybe explain a little bit more in depth of what your request is so I can understand it better, please?
Yes, and I will try my best. Thank you. I'll try my best not to stray into argument, but the whole 2 hours or hour and a half or whatever it was, I don't want that. I think that would be a fair request. It's just the 10 minutes or whatever where somebody tells Mr. Gates what to do. Mr. Gates, we want you to redact this, but leave the names of senders and recipients. Please do that. And a transcript or just snip off the 15 minutes of the recording that contains that. That's what I'm asking for. And it's not that I know Mr. Gates personally and professionally, and I mean, I don't think he's doing anything contrary, but that's the result of the successful appeal. I mean, so it just makes sense. It can't have a right to appeal, but not a right to know what the result of the appeal was. That just makes no sense. But what we need to focus on, I think, and that sounds like I'm arguing, and I will be very brief, is there is a code that was cited. That is Anchorage Municipal Code 2.30.036C. Nothing in there allows for indefinite withholding of executive session tapes. It just doesn't. It says they shall be released unless there's...
Madam Chair, point of order. I'm sorry, but that's legal argument.
Okay, I can finish up, Madam Chair.
I will not argue. I would implore you to read 2.30.036C.
I need to rule on the point of order, and Ms. Zalatel, would you state that again, please?
Sure. I believe counsel was providing us a legal argument about why he thinks the appeal should be granted and not answering the clarifying question.
Thank you, Ms. Zalatel. I concur. So please, Mr. Severin, if there are any other clarifying questions Ms. Allard has.
I don't think so. Madam Chair, I just wanted to say, based on what Sam has just said to the body, that he's not asking for the entire executive session, I don't find anything that, let me use the right word, jeopardizes the executive session and what was said in it by them bringing it down to a very specific question. Thank you, Madam Chair.
Thank you, Ms. Allard. Thank you, Mr. Severin. Ms. Kennedy?
Thank you, Madam Chair. You know, I was kind of along the lines of what Mr. Weddleton had started to talk about in terms of when we voted on this appeal or the denial of the appeal to begin with. I remember it was so convoluted that the way the motion was made that several of us didn't know what voting yes meant versus what voting no meant. And I remember that both Ms. Allard and Mr. Weddleton left because they didn't know how to actually answer the question being posed in the shape of a motion. And I remember voting specifically yes on that so that I would have the ability to actually move to reconsider right away, because I felt like, I think somebody called the question or something, so there wasn't any more discussion, but I think there was a better way to handle that particular motion, to put it in the affirmative, because apparently the way we voted on it, I believe, if I remember correctly, the motion said to deny the appeal except for the items that were approved for the assembly attorney to deal with. So it was, anyway, it was just kind of, like I said, really convoluted. I think we still have a lot of loose ends with that whole conversation, the way the whole process worked, not to mention whether or not some of the content could actually be considered confidential. I think that was probably the biggest question that we have to answer, right? Is information considered confidential? And, you know, it just seemed like there were a lot of things in code that didn't make that very clear, and the idea of some of us, I mean, well, at least I came away with the fact that I think there were things that the Assembly needs to do to clarify that in the future, so we don't get into these rat's nests worth of legal arguments, in which I think is kind of what we've sort of created here. And I believe that even this basically leaves the Assembly just ripe for a lawsuit. So I'm going to vote against this as well, because I think the last process was terrible and really didn't address the questions and didn't answer the actual need that was brought forward. So anyway, that's, I guess, just the end of my comments on it then, Ms. Chairman. Thank you, Madam Chairman.
Thank you, Ms. Kennedy. Mr. Weddleton?
Oh, thanks. Oh, so this is for Mr. Severin. So in Mr. Gates' letter to you on March 3rd, he says the changes from the December 17th redaction should be obvious. So were they obvious? And if they are, then you kind of know what was stated then, right?
Well, I mean, it's 591 pages of half blacked out and half not. So it's obvious that the body gave direction to be more transparent, which is much appreciated. I mean, I think that's very good. It's not, but it's not obvious. I mean, I'm not sure why, I'm going to start arguing, but I'm not sure why that should have to be divined that way. When nothing in the code allows that to be kept hidden, so I don't know why we're hiding it. But it was obvious that the Assembly gave direction to redact a lot less, and that's much appreciated. What the scope of that is it really would require a lot of guesswork. It's just, it's 591 pages. It's really hard to, it's short of having my staff take a week to compare line by line or something. It's just it's a lot of, it's not, I don't think it's that obvious.
All right, thank you.
Thank you, Mr. Weddleton. Ms. Zalatel?
Thank you, Madam Chair. I think we need to really think about this in, the distinction of how advice or direction was given to council, because it wasn't one sentence. There was, conversation. And so I think a lot of the reasons for keeping something confidential in an executive privilege, in a lot of ways it was a conversation, and some of that was pre-decisional, and I don't feel comfortable with that being released. That is the purpose of executive session, is to have that conversation with council. We are 11 members, and you throw out an idea and it morphs and it changes, and we all know that. And that is how you get to a point where direction can be given to council. So I don't think it's as simple as it's perhaps being portrayed to be. So I think I would caution on, it feels like a very slippery slope, because you release one snippet, well, now I want more for more context, and now you're really into the whole purpose of the executive session.
Thank you, Ms. Zalatel. Ms. Allard?
Thank you. Sam, I'm going to ask you a question, Madam Chair, but do not.
Okay, understood.
In your legal opinion, do you believe, based on your knowledge of code, that the body is violating it by denying this request without an argument?
Yes, I do. And it is, I think any decision should, line by line, go through 2.30.036C. And that will be the answer, not whether it's a good idea or not to disclose it. I don't think that C, 1 through 4, I don't think those are met.
Think or believe or no? You said I think.
I'm trying not to argue. They're not met. The elements that are there at C 1 through 4, those don't fit with, those mandate disclosure subject to a request.
All right, thank you. Thank you, Madam Chair.
Thank you, Ms. Allard. Mr. Perez-Verdia?
Thank you. Just one more time, actually, Ms. Zalatel pretty much said what I was going to say, but the direction that was given was not succinct. It was mixed in with conversation that was understood to be confidential by all of us. And I think that's the crux of the challenge here. And the result, the direction that was given, is what happened. So it's clear. The direction was clear because it's actually what was redacted. And so I just want to put those two things on the record. Thank you, Madam Chair.
Thank you, Mr. Perez-Verdia. Seeing no other members in the queue, members may proceed to vote on the motion to amend AR 2022-125 to check the box, denies the appeal, and the decision of the public official is affirmed. The amendment passes 6-3. We now have before us the main item, AR 2022-125, as amended. Seeing no other members in the queue, members may proceed to vote on the motion to approve AR 2022-125 as amended. The motion passes 6-3. That brings us to audience participation. If there are any members of the public who wish to speak, please come forward. Welcome. Please state your name for the record, your community council, or the area of the municipality in which you live.
Sam Severin, Airport Heights. Thank you for your time tonight. I'm sorry if I became argumentative. That's what I do for a living, and I was trying to refrain from it. So appreciate your time tonight.
Thank you for your participation. Are there any other members of the public who wish to participate? If so, please come forward.
Madam Chair.
Ms. Allard?
I was in queue to ask Mr. Severin a question, if that's allowed, please.
Sure.
Thank you, Madam
Come on
Chair.
back, Mr. Severin, if you don't mind. Go ahead, Ms. Allard.
Mr. Severin, do you know that you have 3 minutes to say what you want to say without interruption from any of the Assembly members, and you're just allowed to go ahead and say it?
I do. I appreciate it.
Okay.
Thank you for allowing me that opportunity. No, I think I'm concerned that the code was not followed, but I respect the procedure and understand the decision's been made, and we'll go from here. Thanks.
Thank you. Seeing no other members of the audience wanting to participate, we will move on to Assembly comments, and we will start with Mr. Weddleton.
No comments, thanks.
Thank you, Mr. Weddleton. Ms. Allard?
Thank you, Madam Chair. I just wanted to say that I think that as public officials, we should be completely transparent, and if there's limited disclosure on certain items that aren't, I guess, a defamation of any particular persons, that we need to reevaluate releasing information in a timely manner. Indefinite is not what we should be doing. Thank you, Madam Chair. Appreciate it.
Thank you, Ms. Allard. Mr. Peterson?
Thank you, Madam Chair. No response this evening.
Thank you, Mr. Peterson. Mr. Rivera?
Thank you, Madam Chair. No comments.
Thank you, Mr. Rivera. Ms. Kennedy?
Thank you, Madam Chair. If you'll indulge me for a couple of minutes. Thank you. This is essentially the last Assembly meeting that I'll be able to attend. I mentioned a few months ago that I had a trip planned with my husband before the calendar was changed to basically extend a week before we would have the certification of election. And so I fully expected the 19th to be my last meeting, and the new member would then take office. But my trip is planned, and I'm leaving out of state in another, just later this week, and certainly before the meeting of the 26th when the certification will actually occur. So I just wanted to take this opportunity to briefly say a few things. First, I have to thank the Lord God for giving me this opportunity. It's been a wild ride, but that's how God does things, to keep us relying on Him and trusting Him. So there's been joy, and of course everyone knows there's been frustration, but I look on all of it as an incredible blessing from His hand alone. I especially want to thank the community of Chugiak, Eagle River, Jay-Bear, and Eklutna. My community is such a conglomerate of so many different kinds of people and lifestyles and likes and dislikes and certainly opinions. And I've always appreciated how we managed to make it all work. So it's truly been an honor and a privilege to serve this community and all of its members. And I want to acknowledge all those Chugiak Eagle River Assembly members who came before me, recognizing folks who were in this position or the other Chugiak Eagle River seat, like Gretchen Wemhoff, Amy Domboski, Fred Dyson, Bill Starr, Debbie Osiander, Anna Fairclough McKinnon, Dan Kendall, Ted Carlson, and Craig Campbell always helped remind me of what big shoes I had to fill. All of them played a role at some point during my tenure, and for that I am truly grateful. To the next one in line, Kevin Cross, I say congratulations. I'm very excited for him, and I know he will pour his whole heart into serving our community. I ran for this seat 3 years ago knowing it would be for one term and hoping there would be someone who would step up and advocate for Chugiak Eagle River and Jay-Bear with the love and respect for the community that I have, but someone who would have more energy and enthusiasm to do so for the next full 9 years. And I believe we have that in Kevin Cross. So Kevin, I wish you the best over the next 9 years. To my Assembly colleagues, God bless you all with His wisdom in how you lead this entire municipality from here. And I say that while also thanking Chair LaFrance for mentioning municipality when asking people to state their name and the area of the municipality that they came from. So thank you very much. I appreciate that. That job, though, of continuing to be reminded that we are a whole municipality, not just the city of Anchorage, I wholly leave that job up to Miss Allard, who I have so enjoyed sharing this adventure with, and certainly to Mr. Cross to carry on, and I know they will. So I thank you all, and with that, thank you, Madam Chair.
Thank you, Ms. Kennedy. Ms. Zalatel?
Well, I didn't have any comment, but geez, yeah. Congratulations, Ms. Kennedy. It's been a pleasure. I've learned a lot from you. I've enjoyed working with you. And I hope you enjoy your trip and you get some rest and relaxation. Thanks.
Thank you, Ms. Zalatel. Mr. Dunbar?
Thank you, Madam Chair. I want to echo my colleague and say safe travels to Ms. Kennedy. I hope you enjoy this whole summer not being on the assembly. I think, but we really appreciate having your voice on this body, and I wish you all the best in the future. Also, on an unrelated note, go Warriors. That's it for me today. Thank you, Madam Chair.
Thank you, Mr. Dunbar. Mr. Perez-Verdia?
Thank you, Madam Chair, and yeah, thank you, Crystal, for your service. And it's been a pleasure working with you. I've also learned a lot from you, and I've really enjoyed, especially working on the Public Safety Committee with you. It's been a lot of fun, and it's been a very rewarding experience working with someone who's so thoughtful and knowledgeable and experienced, but really loves this municipality and loves this work. We're going to miss you a lot. So that's all my comments. Thank you, Madam Chair.
Thank you, Mr. Perez-Verdia. So I'm going to go back to those folks who skipped on comments because I don't want to shortchange you now that you know that this is Ms. Kennedy's last meeting. No such thing, Ms. Kennedy. Mr. Weddleton?
Well, thank you, Crystal. Crystal, it's been a pleasure working with you here and on the Community Economic Development Committee and others. So thanks. You've done a great job.
Thank you, Mr. Weddleton. Ms. Allard, did you want to add anything?
I do. Crystal is about, I think, 9 houses down from me. So we hash things out behind closed doors, but thanks.
Thank you, Ms. Allard. Mr. Peterson?
Thank you, Madam Chair, and I also wish Crystal safe travels in many of them. And you know, we had several years working together here on this assembly, on this body, and there were times when we didn't agree, but we were never disagreeable about it. And I'm hoping that type of relationship can be maintained going forward with the new members. Thank you.
Thank you, Mr. Peterson. Mr. Rivera?
Thank you, Madam Chair. Yeah, I want to echo a lot of the comments of my colleagues and just wish you best of luck on your future endeavors. And you know, one of the things that I've learned is even though you may be retired from this body, you're never really done. So best of luck.
Thank you, Mr. Rivera. And I will just add that it's been a pleasure serving with you, Crystal. And I appreciate, too, that you came with a tremendous amount of experience with not just with your community council work, but with the school board. And that's really helpful. So, and I also very much admire the classy way in which you disagree with people. It's, I think Mr. Peterson mentioned that we should aspire to that kind of discourse too. So thank you and have a great summer. And I think I might see you at the concert at West High tonight. And with that, I will ask for a motion to adjourn.
Move to adjourn.
We are adjourned. Thank you all for being here tonight.